Hi, this is Michael Cohen. I'm a Dallas estate and elder law attorney, and I am joined by my good friend and former cohort on our radio station that was going on through 2025 at Don Crawford Jr. So thank you, Don, for joining us.
My pleasure. It was funny when you were saying that. I was thinking about our radio days, and I always used to begin the program and say to you, "Hello, Michael," and you would come back and say, "Hello, Don. How are you?" kind of thing. So that makes me think of those good old days, like your workshops, which are in person, which is old fashioned and helpful too. And I really like those also. But I remember the days when we used to be in radio when it was different than it was
Yeah.
today.
And then at those times, it was somewhat more fitting because I have a radio face.
You're right. No, you don't.
So unfortunately now you have some people have to see me in person, but in any event, you get to see at least our impressions or our whatever we're saying with our hands or our mouth or whatever it may be. So you get a little bit of feel for how we're talking about. It was always funny when, you know, I was about to say something about the free KAAM coffee mugs, and then
Yeah.
you would kind of go, "Oh
There we go.
no."
All right. That's a good and bad memory too. I remember that very well.
Some people still
You
ask
know,
for that, by the way.
what's that?
Some people still ask for
I
it.
know. I bet they do. It's kind of a thing that we had or a shtick or something like that, but it was fun. Regarding the radio show, throughout the years, we did the show like 12 years together, 13 years, something like that, long time. And you used to address ladybird deeds, and you want to address that today and why they're so special and what is now unique about them.
Well, I'm going to talk about something that we have never utilized with a ladybird deed, and that is when would you disclaim a ladybird deed? Or maybe a
Disclaimer.
transfer on debt deed too. But so what would happen? First of all, what is a ladybird deed and what is a disclaimer? What's a ladybird deed? So a lot of times you could use this in estate planning, but we commonly use it in Medicaid because the homestead, although it's an exempt resource, after death, the state has a right to make a claim against the home in Texas for reimbursement to the extent that Medicaid benefits have been advanced. That's
Okay.
like if you're in a nursing home, for example, or getting care costs or medications taken care of by the government. And
Okay.
it's most commonly with people in nursing homes. So even though the home doesn't count if the equity is less than 752,000, if you're single, if you're married, there's no limit. The state has a clawback for reimbursement if it goes by your will or by intestacy. That means if you don't have a will. Now, I mentioned a second ago, I said in Texas, because we're only three states that allow ladybird deeds to protect the home from Medicaid estate recovery. Because it's not going by will, it's not going by intestacy, it's going by deed at death. And since the owner of the property is still in control until they die, it's not subject to Medicaid's 5-year look back period. It's not a penalty if I haven't given it. Now, it is considered a transfer subject to divestment. In other words, you could change your mind before you die. Um, Now, once you have died, you normally it vests in whoever the grantee is. But there is a thing called a disclaimer. What is a disclaimer? A disclaimer is saying, you know what? It's if I had already died before you. And so when you make a disclaimer, it goes to the closest relative, the beneficiary, the descendant generally. So if a parent gives to a child, the child disclaims, it would go to the child's children. Okay.
Okay.
So you say, well, okay, again, why would I do that? Well, let's say that I, the grantee, the one who's received the property, there was a lawsuit threatened, or I've already been sued. Well, I don't want, if I get whatever I have, my creditors can get to. So maybe my children don't have those creditor issues. So I could do a disclaimer so that the creditors could not get, I never got it. as if I never got it. However, if I start having acting as if it were mine by doing something that showed I'm in possession using it. So, for example, if I started either collecting rent or paying the taxes or insurance, perhaps that may be a element to show that it's vested.
Sure.
So you have to, not have done that, at least initially, I would think, because then, now, by the way, you can't disclaim, the IRS always gets their money, or if there's a student loan, you can't get rid of the IRS or a student loan for that purpose. But other creditors you can. All right,
Okay.
so some people might in the future, if they had creditors, then they might disclaim so it goes to somebody who doesn't have creditors. All right, what about the situation where it's just saying, "Oh, gee, the I can't afford to pay the taxes or insurance, whatever." So it's just an affordability issue. Well, okay. So maybe my children can afford that. Maybe it gives me too much resources for Medicaid well, no, I can't do that. I can't do that, come to think about it, because under the Medicaid rules, if I do a disclaimer, then they'd say that's like a gift. So and that would be subject to the 5-year look back period. So you can't do a disclaimer for Medicaid. However, if the person can't afford whatever it may be, that property, okay, then there could be a disclaimer and typically goes down the line.
Very
What's
interesting.
another example? Let's say it was an environmental issue. Let's say that you had gas tanks underneath your house or something, some sort of cleanup that would be very expensive. And you might say, oh, gee, I, I you know, I don't want to do that. I don't want to maintain the property.
Right.
Remember, we had years ago, I don't know if you remember this, but on one of the radio shows we had where I think it was Attorney General Reno had this property that took a lot of work. And she had left it for, I think it was the University of Miami. And the University of Miami said, "Oh my gosh, this is a lot of work. We don't want to maintain your property. It's too expensive to maintain. So what we're going to do," so they just wouldn't take it. And so it went to Miami-Dade Junior College or Miami-Dade, some sort of college. He said, "Yeah, we're willing to take the property. We're not going to look a gift horse in the mouth." Uh,
Sure.
and like you would in the Kentucky Derby. Uh, I was joking with Don beforehand that we had gone to my wife and I had gone to the Kentucky Derby, so that's why that was the inside joke, as they say. All right, there's one more thing: is let's say you needed to correct something. Let's say the spouse says, I really this was really intended to be to go to the children of this house. And so you don't have to use this for Medicaid. It was really supposed to go to children, so you could do a deed, ladybird deed on any type of property. So I'll just disclaim it and it'll just go to the children.
Right.
Okay. Now remember, it's got to be those that have to be, uh, let's say you didn't probate the will and you just wanted to go by the deed. The deed would supersede the will, um, unless there was a problem with the deed.
Right.
So generally what we do when you have either a ladybird deed or a transfer on debt deed, we like to mention in the person's trust that even though it's supposed to go outside of probate, we say, hey, just in case there's a mistake, then it's to go, this is what I intend.
Right.
So we just do that ever since. I remember one time we had a transfer on debt deed. Transfer on debt deed is a little bit different. You have a name of beneficiary and then a grantee and then an alternate one. If you had disclaimed to the original, let's say Don disclaimed that Don had a deed that went to his wife Sarah, and if If she died first, then it would go to his trust. Well, if it was disclaimed by Sarah, it would just go to the trust. Or
Right.
if she died, yeah, either way, it would go to the trust. So, so on transfer on death deed, it's list. So then it would go by the alternate beneficiary. On a ladybird deed, it just goes to the closest heir, generally the children. So it's a little bit different.
It's
Uh,
different.
to do a disclaimer, by the way, it has to be in writing. You have to have the legal description of the property. Has to be recorded with the county clerk after it's been signed by the grantee. So it would have to be in writing. The other way is if it went to, let's say it went to that spouse, if she wanted to, she could just gotten the property and deeded it to the children is another thing. But just to let you know, that's one reason maybe why we don't see it very often is because um, there's ways around it. In this case, so I think really the more important situations, if you had a creditor, couldn't afford it, it cost too much, or maintenance were too many ways. Disclaimers are actually more often used in tax planning. Let's say you have an IRA and the um, parent has a high tax bracket and if they were getting this income, then it might be that the child was in a lower tax bracket. Also used in estate planning on larger estates. There's usually when you have a taxable estate, let's say it's right now the estate tax limit's 15 million, you can determine where you get the what you call step up in basis. Is it going to be on, if there's a married couple, is it going to go to the one who died first portion, or is it going to go to the surviving spouse's portion? So there are disclaimer trust used in estate planning as well. So, but the topic here was on ladybird deeds. So I don't know, Don, questions on that?
No, I just know that creditor rhymes with predator, and I worry about that kind of situation because I wonder if objectively we're dealing with creditors each time, or we're dealing with people who are just see opportunities. And we were talking about that with disclaimers and ladybird deeds today, but also last program about Michael Jackson estate and how that all that planning is such a mess too. And I just worry about those situations because when it came to Michael Jackson's estate, we talked about that during the program and about how the attorney should have done more. And that's the great thing, or the reason, the ultimate reason why you should consider Michael Cohen at least going to his workshop in person when the next one is. And that is because Michael has these safety nets in place that you need. That's going to allow you to sleep at night. That's going to allow you to not worry because if something drastic happens, there's always this phrase, there's always this catch-all that protects you in case he misses something, which is very rare, maybe never. But just so you know, in case you're thinking about switching attorneys.
Well, I'm not asking anybody to switch attorneys, but not certainly appreciate your kind words. But the workshops are free. We have free workshops every month. It's no obligation. If you want to go to one, great. Would love to see you there. Answer any questions. We ask people what they want to know, and then we have a short presentation, but we ask people what they want to know, and we answer it either immediately or somewhere during the presentation. And so, if you want to go to that free estate planning essentials workshop, just call 214 720 0102. That's 214 720 0102, or sign up online at dallaselderlawyer.com. That's dallaselderlawyer.com. And by the way, I'm going to say one more thing about Lady Derbies. Even though usually we use it on a homestead, um, it could be on any type of real estate. It could be on mineral right. If you have, let's say you have property with oil and gas, and you could do a ladybird deed on that too. So it's any type of real estate. Well, anyway, if you're interested in knowing more about either ladybird deeds or anything else regarding estate planning or Medicaid, feel free to join our workshop by calling that number of 214-720-0102. Did you have a question, Don?
No, saying goodbye.
All right. Well, then we'll see you next time.
Thank you, Mike.
Thank you.